what else? I forgot. Okay. So just system on, right?
Yes, ma'am.
Okay, and the door's open? Yes, no, maybe so? It's red. Does that mean open?
It was unlocked.
Okay, thank you. All right, so we're on the record, or at least streaming.
I was going to get started in a couple of cases we call it attorney.
Sure.
Yesterday at the end of the docket. DeAndre Smith and Tony Randall. I have. I don't know if you have them.
It would be in the pile, I think. DeAndre Smith. I see that one. What was the other one?
Randall.
There's Smith. And Randall. Got it. Okay. All right, where would they be at? What? All right, good afternoon, everyone. This is Judge Levine. We're here today for pretrial conference, for your magistrates hearings for your first appearance. Do we have Tony Randall? Can they hear me? Speaker on. Hello, can I get Tony Randall? Can you hear me over there?
Yes, I can, yes.
Okay, just making sure because it was a little quiet. All right, Mr. Randall, good morning. You're here today accused of robbery with a firearm, 2 counts.
Your Honor, actually, 1 count should be attempted robbery.
Okay, so 1 robbery with a firearm, 1 attempted. Any argument, defense? Because if not, the court's going to find probable cause. I read the PC, and I do find that the elements for the offenses are found. At this time, what is your recommendation?
Your Honor, just for the record, the state, for Mr. Randall, the state is not going to be seeking a no bond. Your Honor, based on the allegations, though, I would be seeking a $25,000. I'm sorry, Your Honor, I didn't realize I was muted. Your Honor, I'm not going to be seeking a no bond hold on count 1 on Mr. Randall. I'm going to be requesting a $25,000 bond on count 1, a $15,000 bond on count 2. No victim contact, no contact with his co-arrestee, DeAndre Smith, and, did I say GPS?
And what say you, defense?
And Your Honor, I'm sorry, I'd also be requesting pretrial release of the GPS monitor.
Okay. 38. Anything regarding Mr. Reedy? I'm sorry, not Mr. Reedy, you're here.
Mr. Romero might have
Mr.
some
Romero.
information.
Yes, Judge, my understanding is Mr. Randall's not in a financial position to post that. If my math is correct, that would be about a $40,000 bond. He's 18 years old. He does side jobs, mostly in landscaping. He does have family that reside in our community. His grandfather, he lives with his mother in Fort Lauderdale, where she rents, does not own her home. My understanding is she works for a retailer in customer service. So that's who he's going to be reaching out to post his monetary bond, but there's no way they're going to be able to afford $40,000. I'm going to be asking the court to consider reducing that monetary amount. I'm going to be requesting on count 1 a $10,000 bond, and on count 2 a $2,500 bond. And I do realize the seriousness of the allegations, so we wouldn't object to also having Mr. Randall be supervised by pretrial release.
All right. At this point, I'm not sure, based on the information provided, that the difference between $10,000 and $25,000 makes a difference to him if he's unemployed and doesn't have the resources himself. So at this point, I'm going to go ahead and impose bond in the amounts suggested by the state as $25,000 and $15,000. And I'm going to also, should he post that bond, require the special condition that he be monitored with pretrial release with the monitor, with the bracelet, I guess.
Yeah, Yes, and
All right, thank you.
Your Honor, as far as no victim contact, no contact with DeAndre Smith.
Okay, the court's going to order no victim. I don't think I have a no victim contact order on Mr.
I don't
Randall.
think you necessarily have to fill one out.
Okay. So at this time, Mr. Randall, you're ordered not to have any contact with the victim in this case and or with the co-defendant in this case, Mr. Smith.
Judge, if I may.
Yes.
Court order level 2 GPS with the monitor.
Yes.
In that case, Judge, there's the cost associated with the monitor. I believe is $5 a day. You heard it basically doesn't have financial resources. Would you waive the cost?
At this point, you can bring it up. The court has no objection to bring it up once with his regular judge.
Yes, Judge.
Thank you. All right, can we have DeAndre Smith?
He's here at Maine. Come on up.
Your Honor, I would like to present some testimony in this matter.
Mr. Smith, you're here accused of robbery with a firearm on counts 1 and 2. Do you want to change that to attempt as well?
Yes, count 2 should be an attempt, Your Honor, and count 7 should, it was a misbook. It should just be, you can find no PC on count 7. It shouldn't have been attached.
No PC, yeah, there's no other, there's no count 7, right? Okay, no PC on count 7. Court does find probable cause on counts 1 and 2. You also have KPSs for traffic on counts 3, 4, 5, and 6. On counts 3, 4, and 5, bond is $250 on each one. And on count 6, is that RR?
Yes, it is.
Okay, so that leaves the bond, if any, to be posted on counts 1 and 2. State.
And Your Honor, if Detective Hoover is present before the court, if he could be placed under oath.
Raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Put your hand down, state your name for the record.
Stephen Hoover,
You may proceed.
Thank you, Your Honor. Detective Hoover, who are you employed by and in what capacity?
Broward Sheriff's Office, robbery detective.
And were you called to investigate a robbery that occurred shortly before midnight on January 12th, 2019 in Dania Beach?
Yes, I was.
And can you tell me where the location of the alleged robbery was?
It was Dania Beach at 750 Northeast 7th Avenue.
And have you had an opportunity to review a probable cause affidavit provided by Deputy Daniel Roca of the Broward Sheriff's Office?
Yes, I have.
Okay. And based on your investigation, are the facts alleged in the probable cause affidavit accurate?
Yes.
Did you have an opportunity to speak to the alleged victim, Thomas Percival?
Yes, I did.
And did Mr. Percival advise you approximately how far Mr. Smith was from him when he robbed him?
He got out of the vehicle, and then when he actually took his property, he said he was within 2 meters, which is approximately 6 feet.
Okay. And based on your investigation, was he certain that Mr. Smith was in possession of a firearm when this robbery occurred?
Yes, he described the firearm in pretty good detail.
Okay. And could you tell the court approximately, according to the booking, Mr. Smith was arrested in 106 Northwest 11th Avenue?
Yes.
In what city?
Fort Lauderdale.
And approximately how much time passed between the arrest, or when Mr. Smith was initially apprehended and when the robbery occurred?
It's roughly 30 minutes.
And based on your experience and training as a detective, as a law enforcement officer, was there sufficient distance between the two locations and time that Mr. Smith could have discarded of the firearm?
Yes, absolutely.
Where law enforcement would not have been able to locate it?
Correct, because the location was just south of or down close to the airport, and where they were apprehended was just north of Broward Boulevard.
And my understanding was that there was some of the stolen property from the victim found in the vehicle Mr. Smith was in.
Yes, there's a wallet with various forms of identification, as well as the phone case, but not the phone itself.
And was there any clothing located in the vehicle?
Yes, there's a pair of dark pants.
And those pants, would that be consistent with the pants that the victim said the person that robbed him was wearing at the time of the offense?
Yes, that's what he described.
Your Honor, I have nothing further at this time. Based on the allegations in the probable cause affidavit and the testimony from Detective Hoover, I would be seeking a no bond hold on count 1 upon a finding of proof evident or presumption great for first appearance purposes only.
And we would be objecting to the court making a finding of proof evident presumption great at this point in time. Proof evident presumption great is the highest standard of proof that we have in the criminal justice system, and the state has not met that very high burden. No firearm was found in the vehicle. The cell phone was not located in the vehicle. And Mr. Smith should be entitled to a bond at this point in the proceedings, Judge. To hold him no bond at this point in time, our position is that that would be an incorrect decision from the court. If, however, the court does feel that proof evident presumption great has been met over our objection, then based on any factors that Mr. Romero might care to add to my argument, I would urge the court to exercise its discretion and set bond for Mr. Smith.
Does Mr. Smith have any prior convictions?
One moment, Your Honor. Your Honor, the only thing I see is a resisting without violence from last year. Just the KPCC stands before the court on today.
Mr. Smith, at this time, based on the circumstances of the offense and the testimony received in court in addition to what's already in the probable cause affidavit, the court finds that the evidence is sufficient to find that proof of guilt to be evident, and therefore the court is going to hold you no bond at this time.
Your Honor, as far as count 2, I would just...
As for the purpose of this hearing, court has no objection for you in front of the regular judge.
And just as far as the attempt charge, I'd ask for the same bond you said on this co-defendant, $15,000.
That's fine.
And again, just request no victim contact, no contact with Tony Randall.
All right, no contact with the victim in this case, and no direct or indirect contact with the co-defendant as well. Thank you.
As far as the monetary amount on count 2, I realize the court's having made findings as far as proof evident presumption great, holding Mr. Smith no bond. He's going to have to be seeing his division judge anyway, so we'll defer as far as bond request amount on count 2 for that time.
All right, thank you.
Judge, there is another case I'd ask the court to take out a turn. I know you may not have a docket, but page 19, Kelvonte Dancy, D-A-N-C-Y. He has some children who are here on his behalf. They're out in the hallway.
Yeah, he's back there. Ryan.
What was the name again?
Dancy, D-A-N-C-Y.
Calvante Dancy.
Calvante? Okay.
He's on page 19, Judge.
Thank you. All right, is that Mr. Calvante Dancy there?
Yes.
All right. The court has reviewed the probable cause. I do find that there is probable cause for the offense of abuse of child without great bodily harm. At this time, what are you recommending, State?
Your Honor, we're requesting a $2,500 bond, no victim contact.
And what say you, Mr. Romero, if anything?
Judge was working. He was working for a company, Ryder, the truck rental company, located in Doral. He was making about $13. Unfortunately, he lost his job, and now he's currently looking for work. So he has no money coming in. He is going to be reaching out basically to his family. His mom works at the post office. I'm going to be not that different, but I'm going to be requesting a $1,000 bond sum rather than $25,000, considering he has no money in the bank and he owns no property, Judge.
Is he going to, if the court, is he going to be staying somewhere other than the home with the child alleged in this case?
Judge, my understanding is he does not reside with the alleged victim.
All right, the court's going to order no contact, no unsupervised contact with the victim in this case until, I guess, further investigation by the Department of Children and Family. And I'm going to allow him to postpone the amount of $1,000.
That's good. Do you recommend any sponsors? Or
Anything further? I'm sorry, yes, ma'am? Okay. If she'd like to add something, just put it on recall, okay? Can you ask Mom if she doesn't want supervised contact, Mr. Reedy? Mr. Reedy, can you ask Mom if she does not want supervised contact or if she does?
That I don't know,
Okay.
Judge.
I
Hi.
actually wanted to speak on something about the detective.
All right, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Sure, go ahead.
So the detective basically coerced and made her say those things because
Okay.
I went to her and I asked her myself, and she told me that they told her to say that.
All right, so at this time, you want him to have contact with her?
If I'm around, yes,
Okay.
I don't mind.
All right, so we'll continue with the order for supervised contact. All right, thank you.
Thank you.
All right, Nicholas Naylor?
My understanding, North Broward, Judge?
Thanks.
Mr. Naylor declined our invitation to join us this morning, Your Honor.
All right, so do I reset that?
I would ask that it be reset since a no contact order is, I believe, necessary.
All right, continue with the no contact pending the reset. Elaine Arney?
Mr. Arney is here present, Judge at Maine, and he declined the services of public defender.
All right, Mr. Maine, you understand that this is your first appearance hearing where the court will be making a determination as to whether or not there's probable cause for the charge that you're accused of, and then making a determination as if there is probable cause, what circumstances for your release will be ordered. It would be in your best interest to have an attorney represent you. Do you want to hire your own private attorney, or do you wish to represent yourself? Understand that the Office of the Public Defender is there to assist you.
My private attorney is not there right now. I don't have his phone number by head to contact him.
If you tell me his name, we can contact him and reset you for the afternoon if you'd like. Yes, there's somebody here. Hold on. Who are you, sir?
I'm his brother. I'm his twin.
Okay, you're his brother?
Yeah, Miss Cynthia. His attorney, Miss Cynthia. I've been trying to contact her since last night.
Okay.
And for some reason I cannot get through.
Okay, so they've been trying to talk to your attorney, but they can't get through to him. If you'd like, I can postpone this to the afternoon and see if they have more time to get a hold of him. Would you like me to do that?
Yes, please.
Okay, I'll put it on the afternoon. All right, thank you.
One thing, I was just trying to bail him out.
All right, well, you can do that too. Oh, maybe not. What is it? Is there a bail on this? No.
His wife right here with me.
All right, well, not until we have the magistrate hearing and he has a right to have his attorney present. So if you can get a hold of Lori and have him be here by 1:30, we can make the decision then. Okay?
Okay.
I'll see you later this afternoon then. Is that 1 o'clock, right? 1 o'clock? 1 o'clock, sir.
Sir? 1 o'clock.
1 o'clock. Osby Miller?
Mr. Miller is here present, Maine. He's approaching, Judge.
All right, Mr. Miller, you're here today accused of violation of an injunction order and violation of probation. And the court does find there's probable cause for the violation of the injunction. And on the VOP, I'm trying to find it. Is there a set amount on that VOP?
Sorry, Your Honor?
Is it is it a VOP because of the violation of the injunction?
Yes.
Okay. The court finds a violation pursuant to 948.06 based on finding the probable cause of the violation of the injunction order. At this time, state, what do you recommend?
Your Honor, I'm going to be requesting $10,000 bond on count 1, pretrial release of the GPS monitor. Mr. Miller was arrested last year for burglary of a structure with battery, tampering with the victim last year against the same alleged victim. In 2017, he was arrested for burglary of a dwelling with battery, aggravated battery, false imprisonment, tampering with the victim against the same alleged victim. Those charges were dropped. In 2005, he was arrested for aggravated battery. That was dropped. Battery on a law enforcement officer, 02. Nothing further, Judge.
What say you, Mr. Romero?
Judge, Mr. Miller lives here locally in Fort Lauderdale. He's self-employed. He does carpentry. Last time, though, however, he had a client was approximately 3 weeks ago, and he only got paid $60. So his financial resources, as you can see, is quite limited. He's been residing in our community his whole entire life. He's 35 years old. I'm going to be requesting $1,000 bond on count 1, Judge.
Based on the circumstances of this offense and his history of prior convictions and tampering with the witness, and the court's going to hold him no bond on violation for probation, and is going to impose bond on count 1 in the amount of $25,000. An order no contact with the victim. Again, this time, hopefully he'll listen.
And, Your Honor, as far as the state's request for a GPS monitor?
Granted. Diane Washington.
Ms. Washington is approaching, Judge.
For count 1 is $25,000. Count. Ms. Washington, good morning. You're here today accused of possession of cannabis less than 20 grams, and you also have a capias for a misdemeanor offense of $250. Court does find probable cause on count 1. Bond on the misdemeanor is $250. Court will post bond on count 1 in the amount of $100. And you're set for court on the 16th. Good luck to you.
Judge, actually, in speaking with Ms. Washington after conversing with her regarding the new law offense and the unlawful false name, the capias, on the 2017 offense, she wishes to ask the court if the court would consider resolving these matters here today and extending an offer of time served on count 3 and withhold on the cannabis offense on count 1, taking judicial notice of time served.
State any objection?
I'm sorry, what was the request?
They want time served on both
Your Honor, the offer from the state would be a withhold on 1, adjudication time served on 3. Obviously, on count 2 would have to be an open plea since it's a municipal ordinance. All
right. What was count? Oh, sorry, that goes to you. All right, raise your right hand, Ms. Washington. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Put your hand down, tell me your name.
Diane Washington.
How old are you?
63.
And how far did you go in school?
12.
And do you wish to resolve your case today via plea of guilty or no contest?
Yes, ma'am.
You have a possession of cannabis, an open container, and giving a false name. Those are 3 misdemeanor offenses. If you wish to resolve them today, the court's just going to give you adjudication time served on all 3. You don't drive, do you?
It would be a request for a withheld adjudication on count 1, Your Honor, because that would have an adverse effect on her license if she was convicted.
Miss Washington, do you drive?
I have license, but I don't drive a car. I don't own one.
Okay. All right, I'll give her withhold on count 1. All right. At this time, is it your desire to give up all the rights that you have in the trial in order to resolve this case today?
I'm sorry, ma'am.
Is it your desire to give up your right to go to trial and take care of all these cases today?
Yes.
All right. And at this time, do you plead no contest to all 3 charges?
Yes, ma'am.
Court accepts your plea. If you find there's a factual basis to support the plea based on review of the Probable cause affidavits will find you freely, voluntarily, intelligently waived your rights and you will enter this plea without the advice, with the advice of your attorney, and that you understand the charges and the consequences, and accordingly withhold on count 1, time served on counts 2 and 3. Court costs on count 2 is $50. I don't know. How much? $70. 78. And on count 3, it's $293. Can you afford to pay or do you need to do community service work?
I don't have any money today.
I'll give you
Requesting 6 months, Judge.
I'll give you
She's
6
on
months to
disability.
pay. I'll give you 6 months to pay, and you have 30 days to appeal. Good luck to you. Teresa Jones,
Medical reset?
again?
Yes,
Or-
Your Honor.
Okay, thank you. Oh, I thought that was from last time, sorry. Jamie Carrick?
She's here present, Judge, on Main. She's approaching.
Ms. Carrick, you're accused of possession of cocaine. The court does find probable cause. State any recommendation? Other than the $1,000?
This is Corp. Yeah, Your Honor, just to advise the court, I'm showing Ms. Carip has possession of cocaine from 2017, prostitution from 2016, that she just pled out a few months ago. I'm not asking for any kind of modification.
All right, defense, what say you, if anything?
Judge, at this time, nothing to add from the defense.
All right. Bond amount of $1,000. Good luck to you. Yesenia Calderon?
North Broward.
Good morning, Ms. Calderon. You're here today accused of disorderly conduct. You also have a probation violation, trespassing, and another probation violation. The court Yes, ma'am.
Can I resolve the case today?
No, you're unable to resolve the case today. The court does find probable cause for counts 1 and 3, and the court does find that, in light of that, that you violated your probation pursuant to 948.06 on case number 18032440 and case 16086661. On those probation violations, the court's going to hold you no bond until you see your judge, and then set bond in the amount of $25 on count 1 and $25 on count 3. Good luck to you. Love to see your judge. Cynthia Rivers.
Medical reset?
Okay, thank you. Tavon Lane.
To Your Honor.
Good morning, Mr. Lane. You're here today on a capias on 18575260C28. Bond is set in the amount of $1,000. Good luck to you. Ellis Jones. I'm sorry, what did he say? Where?
Hold on, Your Honor.
Thank you. Mr. Jones, you're here today on a capias. Bond is set in the amount of $1,000. That's for the offense of trespass.
Judge, I'd ask for a $100 bond. It's a misdemeanor trespass. He's got no bond holds on counts 1 and 2.
State any objection?
No.
So ordered. 100 it is. Billy David Brown.
Conte.
Thank you.
To Your Honor.
Thanks. Mr. Brown, you're here today on a capias for a misdemeanor.
Yes, ma'am.
Bond is set in the amount of $250 for obstructing traffic, no permit. Good luck to you.
That's it?
That's it. James Fonseca.
Hold on, Your Honor.
Mr. Fonseca, you're here today on a capias for a misdemeanor for the offense of petty theft. Bond is set in the amount of $500. That's it. No. Hannah Travis.
Main jail.
Mr. Hannah, you're here today for a violation of probation, a resisting officer without violence. The violation of probation alleges you'll be held no bond till you see your judge on the 16th. It's for failing to report and because you missed a scheduled appointment. Good luck to you.
Your Honor, I apologize. If it pleases the court, I have another case where I have a detective present.
Okay, no problem. And on the resisting, the court sets bond amount of $100. Who was it that you wish to call?
Lenford Gibbons. He's towards the way end of the docket, Judge.
Judge, he's on page 22.
All right, thanks. Still searching.
Judge, he advised me he's going to apply with the public defender's office. I'm going to need some time to speak to Mr. Gibbons.
All right, go ahead and talk to him.
Thank you.
While I look for his paperwork. All right, got it. All right. Neil, Willie, is that with you or somewhere else?
Willie Neal?
Yeah.
He's here at Maine. Have a seat, sir. Mr. Willie Neal, come on up, sir.
Mr. Neal, here you're accused of driving while license is suspended and having failed to attach the registration, the license plate that was not assigned to the vehicle that you were driving on that day. Bond in count 2 is set in the amount of $100 and ROR on count 1. Good luck to you, sir.
Judge, Mr. Neal has asked me to request that the court consider an ROR on this nonviolent offense. He's 68 years old, been here his whole life. He does have priors, but from what he advised me, it was at least about 2 years ago. He's promising to come back to court, so he's asking for the court to consider an ROR.
State, does he have any other previous driving while licenses suspended? I don't have his driving record in front of me.
I'm checking that right now, Judge.
Ah, thank you. I'll get it in a minute. Thanks, Neil.
I can't tell you while you're looking, Judge. I'm showing his last formal arrest in Broward County was in '06.
All right, let me go look real quick. Granted. Sorry. Well, go ahead, ROR, Mr. Neal.
Thank you,
Yeah.
Judge.
Thank you. All right. Let's go back to Mr. Gibbons.
Mr. Gibbons is here at Maine, Judge.
Okay. All right, Mr. Gibbons. You're here today accused of robbery with a weapon, aggravated assault with a deadly weapon, without the intent to kill, and count 3, another robbery with a weapon, with no firearm or weapon. Sorry.
Your Honor?
Yes.
I would just ask, before the court makes any determination, I'd ask if the court could take testimony from Detective Russ of the Hollywood Police Department regarding count 1. The state is going to be seeking a finding on robbery with a deadly weapon, which is punishable by life offense.
Okay, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? State your name for the record.
Detective Willie Russ, R-U-S-S.
All right, you may proceed.
Detective Russ, you are familiar with an alleged robbery that occurred on September 1st of last year at 420 South Dixie Highway in Hollywood?
Yes, I am.
And I'm sorry, who are you employed by and in what capacity?
City of Hollywood Police Department, Violent Crimes Detective.
Okay, thank you. And you authored the probable cause affidavit for this arrest?
Yes, I did.
And in your probable cause affidavit, it mentions that the defendant was armed with a long knife?
Yes, sir, a large butcher knife, I believe it was.
Specifically a large butcher knife?
Yes.
And did you, in the course of your investigation, did you have an opportunity to take a statement from the alleged victim?
Yes, I did.
And did the victim ever advise you that he had fear or concerns for his life and safety when this robbery occurred?
Yes, he was. He was in fear for his life. Also, that when he returned on the 11th to rob him, that's why he didn't stop him, because he was still afraid because of what he'd done on September 1st in 2018. And
did there come a time where you were able to take a post-Miranda statement from Mr. Gibbons?
Yes, this morning I did.
And was the statement recorded?
Yes, it was.
How was it recorded?
It was video and audio recorded.
And did he make any statement as far as his involvement in these the two robberies before the court?
Yes, Mr. Gibbons confessed to the robberies and said that he's addicted to narcotics.
I have nothing further for Detective Russ. Your Honor, based on the testimony before the court that the knife that was used in this robbery, in the first robbery, was a butcher knife, that the manner in which it was used is detailed in the probable cause affidavit, the victim's statement that he was in fear for his life when this occurred, and testimony from the detective that post-Miranda he provided a audio and video recorded confession of the crime. I would ask the court to make a finding for first appearance purposes only of proof evident or presumption great, seeking no bond hold on count 1 for robbery with a deadly weapon.
Mr. Romero, anything?
Oh,
sorry.
I don't know if it was clear from the detective's testimony whether Mr. Gibbons admitted to having a knife or not. I understand he confessed. Obviously, we don't have that confession before us here today. For some reason, the detective and the state decided that they would ask this court to impose the most strenuous and strict pretrial detention, but not provide the court with the most damaging evidence against Mr. Gibbons, which would cause me some concern if I were the court as to why that confession or statement has not been played today. That being said, proof evident presumption great is the highest standard of proof that we have in the criminal justice system. The state, having failed to introduce any evidence at all or introduce Mr. Gibbons' statement at all, has failed to meet that very high burden. Therefore, I would ask the court to set bond for Mr. Gibbons. We don't know if a knife was ever recovered. We don't know if there's any video surveillance from this store. There's just too many things here that we just do not know for this court to find proof evident presumption great. If the court does find that standard has been met over our objections, we would ask the court to exercise its discretion and set bond for Mr. Gibbons.
I reviewed the probable cause affidavit, taken into consideration the testimony of the detective in this case, and the court finds that proof of guilt to be evident and or the presumption to be great in this particular case, and as a result, the court's going to hold the defendant no bond for purposes of this hearing only. And
Your Honor, if I could be heard on counts two and three.
Yes.
Your Honor, I'm going to be seeking a $50,000 bond on each count, specifically not only based on the allegations, but in 2010, Mr. Gibbons was convicted of 2 counts of carjacking, aggravated fleeing and eluding. He violated probation and was sentenced to just over 83 and a half months in Florida State Prison.
Anything further to add, Mr. Romero, regarding that?
Yes, Judge. Right now, I do realize he's being held no bond on count 1, but $100,000 on counts 2 and 3 is something that is beyond Mr. Gibbons' financial resources or his family. He works at Taco Bell. He's been there for 6 months, making $8.27 an hour. Besides that, Judge, he is going to school. He goes to Tense McFadder Trade School, where he's trying to pursue some sort of career with culinary arts. He's a graduate of Dillard High School. He's 27 years old, been here in South Florida his whole life. He lives with his sister where they rent, they do not own, an apartment where they've been living at for the past year and a half, and their monthly rent is $1,250. She works in customer service for American Express. That's the person she's going to be reaching out to. She can't afford that $100,000. I'd ask you to take that into consideration, determining reasonable bond amount on counts 2 and 3.
On counts 2, the court is going to impose bond amount of $50,000. On count 3, the amount of $25,000. The court does find that based on his prior convictions, he does pose a danger to the community, and should he post bond and the no bond be released, he's to be on a monitor and no contact with the victim in this case, either direct or indirect. Thank you. Torrey Hendricks.
Mr. Hendricks is here present, Judge at Main, approaching.
Mr. Hendricks, you're here today accused of driving a vehicle while your license is suspended. With knowledge, bond is set in the amount of $100. Sean Cohen, anything further?
I'll call your sister right afterwards, okay?
Sean Cohen?
He's approaching, Judge, here at Main.
Mr. Cohen, you're here today on a violation of probation and a capias. The violation, probation, you'll be held no bond until you see your judge. And on the capias, bond is set in the amount, for the traffic violation, bond is set in the amount of $2,000. And your next court date is the 16th. Joe Castro?
He's approaching, Judge.
Mr. Castro, you're here today accused of driving a vehicle while your license was suspended with knowledge, and driver presents with non-current proof of insurance. And there's also a writ of arrest with a purge of $271 on the driving while license suspended. That's a ticket. So what's a driver present? No. Explain, State, because I thought no proof of insurance was a ticket.
I think it's, there is a situation where you can't.
All right, I'm going to ROR him on count 2. The writ arrest, $270.60. Hopefully you'll post that and you'll be on your way. Good luck to you, sir.
I'll call your father right after court, sir.
Gregory Stafford.
He's here, Coach.
Mr. Stafford, you're here today on a capias for a misdemeanor. For the offense of petty theft, bond is set in the amount of $100.
Yes, Judge, and speaking of Mr. Stafford, my understanding is the petty theft occurred at a Target in which the merchandise was recovered, so there's no outstanding restitution issues. Having said that, Mr. Stafford wishes me to ask court if you consider resolving this matter today.
I cannot because I do not have victim impact, but thank you. Elijah Marion.
Mr. Marion is here, present, Judge Amain.
Mr. Marion, you're here today accused of resisting and obstructing an officer without violence and loitering or prowling. What say you, defense? Any objection? The resisting without, court's inclined to post $100.
Actually, Mr. Marion first wishes me to ask the court if you will consider resolving this matter today.
The resisting without?
Or if the state has an offer.
Well, I don't know. Let's find out. State, do you have an offer on the resisting without? On Mr. Marion?
Oh, yeah.
And or the loitering?
Your Honor, this one.
Does he want a time served resolution?
He does, Judge.
Raise your right hand, Mr. Marion. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Put your hand down, tell me your name.
Elijah Marion.
How old are you?
33.
How far did you go in school?
Graduated.
Do you read and understand the English language?
Yes, ma'am.
Are you presently under the influence of any drugs, medication, or alcohol?
No, ma'am.
Have you ever been treated for a mental illness?
No, ma'am.
You're here today accused of resisting an officer without violence. That is a first-degree misdemeanor, carries a maximum penalty of 1 year in the Broward County Jail. If you'd like to resolve that charge today, the court will sentence you to an adjudication and time served. Do you understand your charge?
Yes, ma'am.
And do you wish to accept that penalty?
Yes, ma'am.
Has anyone forced you, threatened you, coerced you to take this plea?
No, ma'am.
The court accepts your plea. There won't be a trial. You're giving up your rights to go with the trial. Is that what you wish to do?
Yes, ma'am.
Do you plead guilty or no contest?
No contest.
Let's advise you, if you're not a U.S. citizen, this plea will subject to deportation proceedings. Do you understand?
Yes, ma'am.
All right. The court accepts your plea of no contest. I do find there's a factual basis to support the plea. Based on my review of the the probable cause affidavit, I find that you freely, voluntarily, and intelligently waived your rights. You only enter this plea without the advice of with the advice of your attorney. Are you satisfied with your attorney's advice?
Yes, ma'am.
That you're satisfied with the advice and that you understand the charges and the consequences, and accordingly I sentence you to an adjudication, impose a sentence of time served. Court costs will be in the amount of $293. Can you afford to pay within 90 days, or do you need more time?
For the court costs? Yeah, court costs, 293. Can I give them more time?
Sure, how much time do you want?
Judge, you would be requesting 6 months.
6 months to pay and 30 days to appeal. As to the loitering, the court finds no probable cause. Daniel Steckel.
Mr. Steckel is approaching, Judge. This is a municipal ordinance. Okay.
Mr. Steckel, you're here today on 2 KPA warrants for trespass on private property and discarding littering upon property. Bond is set in the amount of $100 on each case. Do you understand?
Okay.
All right, good luck to you. Laren Robinson.
He's here, present, Judge.
Mr. Robinson, you're here today for operating a vehicle without having a valid license and failing to register the vehicle that you were driving. Bond is set in the amount of failing to register the vehicle amount of $25 and operating without a valid in the amount of $100. Good luck to you.
Judge, my
Yep.
understanding is Mr. Brabham's been here for, I believe, 4 days now. He's being held on another matter on a $1,000 bond. As you can see, no one could afford to post that bond. He's still here with us. He gets disability. Judge, since he cannot afford anything, we're asking for an ROR on count 3, considering he's being held on a $1,000 bond.
On the operating without a valid? If he can't,
This is Mr. Allison Brabham?
not inclined to do that, especially if he has another charge
Oh,
pending.
Mr. Robinson, I apologize. That's my mistake, Judge.
Okay.
Mr. Robinson, I apologize. He wishes to resolve this matter today.
All right, state any objection? Raise your right hand, Mr. Robinson. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Put your hand down, tell me your name.
Brian Robbins.
How old are you?
I'm 31.
How far did you go in school?
College.
Do you read and understand the English language?
Yes, ma'am.
Do you understand the charges that you're accused of, failing to register the vehicle and driving when you don't own a license?
Yes, ma'am.
And do you wish to resolve both those charges to the sentence of an adjudication and time served? Court costs will be $293.
Can we reduce that?
That is reduced. I'm not giving you court costs on count 2, which would be $133 more.
Okay, that's fine.
Has anyone forced you, threatened you, coerced you to take this plea?
No, ma'am.
If the court accepts your plea, you won't have a trial. All the rights that go with the trial. Is that what you want to do here today?
Yes.
Are you satisfied with your lawyer's advice?
Yes.
All right, do you plead guilty or no contest?
No contest.
Do you understand that by pleading this charge, if you're not a U.S. citizen, you'll be subject to deportation?
Yes.
All right, the court accepts your plea of no contest. I do find there's a factual basis to support the plea based on review of the traffic citation and your driving record. I find you freely, voluntarily, and intelligently waived your rights, that you only entered this plea with the advice of your lawyer, that you're satisfied with this advice, that you understand the charges and the consequences, and accordingly I sentence you to an adjudication, post-court costs on count 2 in the amount of $293, waive court costs on count 1. Good luck to you, sir. Can you pay within 90 days, or do you need more time?
More time. I need more time.
6 months to pay, 30 days to appeal. Rocco Del Cioto.
He's a medical loan, Your Honor.
Okay, so reset. Alex Vilsaint,
Also a medical loan.
Okay. Gutierrez Jason Joseph.
He's in courtroom 5780.
Oh, so he's in court?
He's in regular court. I'd ask the court to reset him for tomorrow.
For tomorrow?
Yes, please.
Okay, reset.
And Your Honor, the only thing I would ask is, okay, never mind. I just want to make sure that he wasn't set for a status tomorrow.
All right, Allison and Bromham.
Mr. Brabham is here, present, Judge Emmy.
Okay.
Page 12.
All right. Welcome, sir. You're here today with Capias for a felony add-on charge of grand theft in the 3rd degree. Bond is in the amount of $1,000.
Judge, this is a gentleman I wanted to bring to your court's attention. He's been here for about a couple of days now, being held on a $1,000 bond. He can't afford that, Judge, so he's requesting an ROR considering he's on disability.
What's his priors?
Well, the other offense he's being held on is another grand theft.
Okay. All right, so at this point, I guess send him in front of his regular judge, and maybe they can do both on something other than that. Kenny DeJuste?
And, Your Honor, on Mr. DeJuste's case, if I could just be heard before you make a finding.
Mm-hmm.
Your Honor, based on my reading of the probable cause...
Mr. DeJuste, are you there? Can you hear? Okay. Yes, okay. Just to say, Mr. DeJuste, you're here today accused of count 1, burglary of an occupied dwelling, unarmed. Count 2, burglary of an occupied dwelling, unarmed. Count 3, possession of burglary tools with intent to use. Count 4, grand theft. And count 5, resisting without violence.
Your Honor, thank you. Based on my reading of the probable cause affidavit, it would appear that this should be 2 counts of burglary structure.
That's what I thought. Okay. I wasn't sure if that second address was a house.
It referred to a parking lot, so...
Okay. So we're going to change count 1 and 2 to structure, which better matches the facts in the probable cause affidavit. The court does find, do you also have the value on the grand theft? Because I might have missed it.
One moment, Judge. I don't see it, so at this point in time, Your Honor, I would ask.
So petty theft?
Yeah,
Or
I'm not going to ask for any time.
Okay. All right, so the court finds probable cause on count 1 and 2 for burglary of a structure. Count 3, possession of burglary tools with intent to use. Count 4, petty theft. And count 5, resisting and obstructing without violence. What's your recommendation as to count 1 and 2 for bond state?
Yeah, Your Honor, I don't, unfortunately, I'm having issues with the system, so I don't know if there's a criminal history.
Okay.
So I'm going to be requesting $3,500 bonds on counts 1 and 2.
And defense?
Judge, my understanding, speaking of Mr. DeJuste, he is not a convicted felon. He's been residing in South Florida his whole entire life. He's 32 years old. At this time, he is currently looking for employment, something stable. While he looks for stable employment, what he does on the side is he does car wash. He makes approximately $100 a week doing that. He lives with his family in Miami. He's been renting at the same premises now for about 3 years. His portion of the rent is approximately $300 per month. He's going to be reaching out to his girlfriend to help post his monetary bond because he doesn't believe his family has enough funds to post his bond. So considering on count 1 and 2, the third-degree felonies, I'm going to be requesting a $1,000 bond on counts 1 and count 2. I'd ask the court to leave the standard bond in place on count 3. And having the court having found PC for a misdemeanor on count 4, I'm going to be requesting an ROR on counts 4 and 5, Judge.
And Your Honor, I understand that the defendant is not a convicted felon. However, in 2007, out of Palm Beach County, I do show that he has been adjudicated on 3 counts of vehicle theft.
Okay. Based on his prior convictions and the circumstances of this offense, and the court's going to set bond in the amount of $5,000 on count 1 and 2, $1,000 on count 3, $500 on count 4, and ROR on count 5. Avery Christopher Campbell.
He's approaching, Judge.
Mr. Campbell, you're here today accused of battery on a law enforcement officer and resisting and obstructing with violence. Court does find probable cause. State.
Thank you, Judge. Your Honor, I'd be requesting a $1,500 bond on count 1, a $500 bond on count 2. Your Honor, I would also advise the court, just want to make sure this case is still pending. Mr. Campbell is out on bond for home invasion, robbery with a firearm or deadly weapon, and 3 counts of aggravated battery with a deadly weapon.
Case number?
15-12056, CF10A.
Court does find probable cause on count 1 and 2. As a result of that, the court is revoking bond on case number 15-12056, CF10A. Court finds that he poses danger to the community, and going to hold him no bond on that revocation, and it's going to set, what say you regarding bond on counts 1 and 2 defense?
Judge, considering he's being held no bond on the 2015 case now, on the third-degree felony, I'm going to be requesting a $1,000 bond. And on the on the third-degree felony, I have no objection to the $500 bond, which is suggested.
Court's going to set bond on count 1 in the amount of $1,500 and $500 on count 2. Andrew Senra.
He's here, present.
Mr. Jenner, you're here today accused of petty theft. Court does find probable cause. Bond is set in the amount of $750.
Judge, there's no way Mr. Senra can afford to post that monetary bond. He works for a labor pool, and as Your Honor know, it depends on a daily basis if there's work, and if there's work, it fluctuates anywhere from $60 to $80 per day. He's been here his whole entire life. He's 33 years old. He lives with his girlfriend locally here in Fort Lauderdale, where they rent an apartment for about $1,200 per month right now. His girlfriend is basically the main financial provider. She works for a telemarketing company in customer service. So that's the person he's going to be reaching out to, but he does not believe after the holidays that she really has any sort of monetary funds to post as monetary bond. So I'm asking the court on this non-violent offense to consider pretrial release for Mr. Senra.
Any objection?
We just want to advise the court, Mr. Senra is currently out on bond on 2 separate felony cases, one for grand theft, the other for felony petty theft.
And case number?
The grand theft is 18-11168, CF10A. The felony theft is 18-10719, CF10A.
Court's going to revoke his bond on both those case number 18-11168 CF10A and 18-10719 CF10A based on the fact that the court finds probable cause for this offense and he obviously poses a danger to the community due to his continued alleged violation of the law, and hold him no bond on both those cases. And on this petty theft, the court's posting bond, setting bond in the amount of $2,500. Willie Kendall Joseph.
He's here, present, Judge.
Mr. Joseph, you're here today because there's a capias issued for possession of heroin and possession of cocaine. Both are being held, I guess those are no bond. And you also have a capias for a misdemeanor offense of driving a vehicle while your license is suspended with knowledge. Bond will be $500 on that case.
Judge, my understanding is being Mr. Joseph, he went to court on counts 2 and 3 yesterday, and I believe he received the county sentence.
Subject was remanded to custody due to being sentenced by Judge Lynch. So yeah, so he's here just on a sentence.
Yes.
So ignore count 2 and 3, and you have bond in the amount of $500 on count 1, which you might want to set him. You want to resolve that, or?
Well, let me ask him if he wishes to resolve the case today.
I mean, the only problem with that is it could affect his driver's license record, and you may not want to do that.
That's what I'm advising him right now.
And it just looking at the sentence, once he completes his SAP, it's mitigated to 120 days, so he's going to have plenty of time to go
in front of his regular judge.
Exactly.
Yeah. All right.
Judge, he wishes to ask the court if you consider resolving this matter today for time served.
Yeah, I'm going to go ahead and let him wait to go see his judge because he's not going anywhere anyway, and I'd rather he have the, his driving record in front of him to make sure that there's no adverse consequences.
Yes, Judge.
Thank you. Mr. Laguerre, McCanson Stanley.
Mr. Laguerre?
Good morning, Your Honor.
Good morning, sir. You're here today accused of possession of heroin, resisting, obstructing an officer without violence, reckless driving, and driving a vehicle while your license was suspended with knowledge. The court does find probable cause to counts 1 through 4. State anything to add or no?
No.
All right. Defense, anything to add?
Yes, Judge. Mr. Laguerre is asking me to ask for the court to consider a straight ROR. 29
No.
years old.
Sorry. Huh? No. Try about something more reasonable.
That's what he wanted me to ask the court. Just
okay.
I'm doing what Mr. Laguerre instructed me. He's working right now. He works at a company called Muffler Pros. Been there for 3 years. He is supporting his household, his mother, and his 4 children. Judge, right now his family is depending on him to actually pay the bills and everything like that. His mom is elderly on Social Security, so that's why he's asking me. He's promising to come back to court and appear, but he's requesting a straight ROR.
Denied. Bond is going to be set in count 1 in the amount of $1,000, count 2 $100, count 3 $100, and count 4 $750. Dalen Garcone.
Mr. Garcone is here present.
Ms. Garcone, you're here today accused of possession of cocaine and resisting an officer without violence. The court does find probable cause. Anything, State?
One moment, Your Honor. I don't think I need to. No, nothing to add.
And defense, anything to add?
Judge, nothing to add.
All right, bond is about $1,000 on count 1, ROR on count 2. Gabriel Hill.
Mr. Hill is present here, Judge O'Malley.
Mr. Hill, you're here today accused of resisting an officer without violence, and you also have a warrant for counts 2, 3, and 4, which will be held no bond, which are for fleeing and eluding, resisting without violence, and driving while your license is suspended. Court's going to postpone the amount of $100 on count 1. The other 3 all no bond.
Judge, I'm going to be requesting on Mr. Hill's behalf a photo order so we can photograph the injuries Mr. Hill sustained. Yes.
So ordered. Daniel Stennett.
Mr. Sten is here present, Judge Maine. Come on up, sir.
Mr. Stennett, you're here today accused of possession of MOMA, also known as ecstasy, and you also have a violation of probation, and on counts 2, and I guess 3 is the same. Based on that possession of MDMA. The court does find probable cause for count 1, possession of MDMA, and as a result, the court finds that you violated your probation pursuant to 948.06. And the court's going to hold you no bond on count 2 for the violation of probation, set bond on count 1 in the amount of $1,000. Jose Tommy?
Judge, she's here present as private counsel.
Good morning, Your Honor. Imabel Ocasio on his behalf.
All right, Mr. Tomby, you're here today accused of violation of the failure to report as a sexual offender on counts 1 and 2 and violation of municipal ordinance on count 3.
Judge, I do have some arguments to make regarding the probable cause affidavit.
Certainly.
It says that he failed to report between October 28th and November 9th, which is a nominal amount of time, but that he did fail to report within the 48 hours. However, it does not state where the probable cause affidavit is devoid of how this police officer knows that he changed the address or vacated his permanent residence on October 28th of 2018.
My understanding is that his previous residence called, or at least...
Well, that's not stated in the probable cause affidavit. It just says that between October 28th and November 9th.
Well, I read that somewhere. Let me go back.
So I missed it somewhere, but...
Let me see. Well, I don't know how would I... Oh, here. On 10/30/2000, I received a telephone message from Witness 1 Williams, who is the property owner of Apartment 1, which is the former residence of the defendant, Tommy. I spoke with Witness 1, who advised that Mr. Tommy moved out on Sunday, October 28th.
Oh, I see that. I had previously missed it.
Okay.
Okay. Also, Judge, for count 3, the municipal ordinance, unless I missed it, I don't see where it says how close or far from the prohibited area he lives. It just says that he lives within 1,000 feet of one of the restricted areas.
All right. Well, I think that's sufficient. So the court finds probable cause on counts 1, 2, and 3. At this time, what say you state?
One moment.
Michael Corker. Michael Corker.
Your Honor, I'll be requesting a $5,000 bond on count 1 and a $2,500 bond on count 2.
Judge, would the court be inclined to ROR him on one of the felony counts? It seems sort of overkill to charge him with failure to report and failure to report vacating the premises. Would the court be inclined to do a $5,000 bond as to count 1 and ROR him on the second felony count? I will tell the court that after we found out that Mr. Tomei was going to be arrested, we were under the impression that he was only going to be arrested on count 3, but he did surrender himself to the Hollywood Police Department yesterday at 11 o'clock in the morning. He doesn't pose a flight risk at this time, Judge. He's been arrested in Hollywood for a really long time, and he has a family and a job in Hollywood County.
Any objection to ROR on count 2?
Well, Your Honor, just to advise the court, Frank, at the end of the day, I was requesting those bonds because I felt a $7,500 total bond would be appropriate.
Okay.
If the court is more inclined to set a lesser bond, then obviously I wouldn't, you know.
At this time, the court's going to set bond amount of $5,000 on count 1 because it is the same violation, even though he has 2 cases. The court's going to ROR him on count 2, and the municipal ordinance bond is set in the $25.
Thank you, Your Honor.
Yeah, right.
Quans Rodney Baker.
Oh, yeah.
What? Okay.
Your Honor, Mitch Polay was here earlier. He's representing him. I mean, I guess he stepped out.
All right, Mr. Baker, I'm going to put you on recall, see if your lawyer comes back, okay? Michael Thomas Catania.
Okay.
Judge, he's, I believe, in the restroom. Can we put him on recall?
Certainly. Regis Rosnick.
Mr. Rosnick, come on up, please.
Mr. Rosnick, you're here today accused of possession of heroin and violation of probation or community control based on that arrest for the possession of heroin. The court does find probable cause for the possession of heroin. As a result, the court finds that there's violation of probation pursuant to 948.06 on case number 18-10088 and 18-4587 and 18-10038 CF10A. And court's going to hold you no bond on the violations of probation, set bond on the possession of heroin in the amount of $1,000.
Good luck, sir.
Patrick Fox Odea.
Mr. O'Day is here present, Judge at Maine. He has private counsel, Mr. James, your private counsel?
I'm not James, Judge, but I'm standing in.
Yeah, I see you.
Good to see you, Judge.
Good to see you as well. All right, Mr. O'Day, you're here today accused of lewd and lascivious molestation. At this time, do you have an argument or?
Not as, Judge, not as to probable cause as
the court does
stated in
find
the
probable
affidavit.
cause to proceed. State, what say you?
Your Honor, I'm requesting a $25,000 bond, no victim contact.
I'm sorry, I couldn't hear. What did you request?
$25,000, no victim contact with SC, no contact with minors until further order of the court. Your Honor, just to advise the court, this is a filed case. It has been investigated by the state attorney's office. So for bond purposes, I think the court can take into consideration that we're past the point of just a mere law enforcement investigation where a report has been submitted to Your Honor.
Okay, what say you?
Judge, the only information that I've had regarding this case is I was able to review a report prepared by DCF. And in speaking with Mr. Linder and going over sort of the allegations in this case, again, I haven't had access to any witness statements, only a DCF report. I can tell you that the facts and circumstances surrounding the situation are more gray than black and white. He doesn't have any priors. He's lived in Florida for 27 years. He's currently been put on administrative leave, so he's not working, but I would ask, and I know that the court isn't able to review the DCF report or any witness statements, but given his lack of priors, I would ask if the court would consider $10,000.
Does he own a home?
Yeah, or an apartment, I believe.
So he's renting?
Are you renting, Mr. Renee?
No, I own.
Okay. And do you have any equity in that home?
I own it. It's mine.
Okay.
Yes, I do.
Okay, and what is the approximate value of the home that you own?
About $250,000.
All right. At this time, court's going to postpone the amount of, set bond in the amount of $50,000.
I don't think it's
Thank you, Judge.
And the court's going to order no contact with the victim in this case.
Thank you.
No, we would, in abundance of caution, we'd also ask for no contact with minors.
And no contact with minors. Kenneth Wayne Melton. Bless you. Welcome, sir. You're here today accused of failure to appear for a felony offense, and you have 2 felony KPSs and 1 misdemeanor traffic KPS.
What are the two?
Let me find it.
More and more KPs.
Let me find it.
The heroin?
Possession of heroin and possession of tetrahydrocannabinoids.
THC.
Thank you. And then failed to register the vehicle. Bond on count 3 on the misdemeanor is $500, and it's a no bond on counts 1 and 2. For failure to appear at a status conference. Sejo, yes.
You have a chance. The gentleman that was on recall,
yes.
He's back, Mr. Catania, whenever the court's
all right, Catania, Michael Thomas, come on up. Mr. Catania, you're here today accused of burglary and unoccupied dwelling, unarmed, petty theft, and criminal mischief. The court does find probable cause on counts 1, 2, and 3. State.
Your Honor, I'm going to be requesting a $15,000 bond. Mr. Catania has a pending burglary of a dwelling with, I reviewed the PC. It's the same allegations that he went to a laundry room as part of an apartment building and broke into it. Now, in full candor, Your Honor, he was ROR'd last month on that because the state did not file an information within 33 days, and the state has still not made a filing decision. I would also note, last year he pled out 2 separate carrying concealed weapons loitering and prowling, drug paraphernalia, and he has multiple drug priors in the past, attempted burglary in 2014, where he was sentenced to 13 and a half months in state prison as a habitual offender, and in 2003, he was convicted of armed burglary of a dwelling, 2 counts of grand theft, violated probation, 2-year state prison.
Defense?
Judge, Mr. Cantagna is financially indigent. He can't afford no monetary bond. The good news is he just found employment for a company called Kegman, where he's working part-time stocking. He's making approximately $9 an hour, but since it's brand new, he hasn't saved any sort of funds to be able to post a monetary bond. He lives locally with his parents in Hollywood. From what he advised me, his parents can't afford to pay any sort of monetary bond. So I'd ask you to take that into consideration, determining reasonable release conditions for Mr. Catania.
Would Mr. Cantagna consider pretrial release with the monitor and special condition that he get a drug evaluation, follow-up treatment if recommended? Oh.
Yes, Judge.
Just to let the court know, on some of the misdemeanor cases I told you about last year, he was on pretrial and ended up violating by picking up new law offenses.
Oh, all right. Never mind.
Well, Judge, maybe with that,
I'm sorry?
you've suggested a drug eval and follow-up, and you might be better suited now for pretrial.
Yeah. Based on his history and the information I received, the court rescinds its offer. Court's going to set bond in the amount of $7,500 on count 1, $500 on count 2, and RR on count 3.
Your Honor, just ask for no return to the location.
And no return to location of this offense.
Thank you, Judge.
Say Joe Polidor.
He doesn't have it.
Mr. Polidor, you're here today accused of burglary of an occupied dwelling unarmed and grand theft. The court finds probable cause. State.
Your Honor, I'd be requesting a $7,500 bond, no victim contact, no return. While I recognize that this involved a carport, I am concerned because it was someone's home.
What say you, defense?
Judge, I'm speaking Mr. Polidor. My understanding is this is his first arrest. He's 18 years old, been here his whole entire life. He's currently working. He works at a call center where he just got that job 1 week ago, making part-time, making $9.50 an hour. Besides that, Judge, he's a senior at Fort Lauderdale High School. He plans on graduating this year. He has a GPA of 2.1. He's studying to take the SAT exam, which he's scheduled to take it in March, and the ACT, which he specifically said February 9th. He wants to go to college to better himself. He lives with his mom in Oakland Park. His mom works at a hotel as a housekeeper, and they've been living at the same residence for about 3 years at that apartment.
State, does he have any, I'm sorry, give me a moment. State, does he have any priors, or did I miss?
Our system is not reflecting that he
Do you guys have any record of any priors for him? All right.
So, Judge, I do understand, as far as this court probably have seen with countless experience, many burglaries. This is, I'm not meaning to undermine it, but as far as burglaries, this is the least egregious.
That's why I'm going to put on recall. I'm going to put on recall to see if he has any priors. No priors?
Okay.
Would be animal to pretrial release?
That's what we'd be asking for, Judge.
So ordered. No contact, no return to the location of the victim's house.
Is that standard or?
Let me give him a minute.
Standard. Behave, young man. And study for that ACT. All right, Jamar Carter.
He's here.
Mr. Carter, you're here today accused of grand theft auto and driving a vehicle while your license is suspended with knowledge. Court finds probable cause on count 1 and 2. Anything to add? If the court imposed bond amount of $1,000 on count 1, and I'll RR on count 2.
Judge, if the state can verify, this is his first arrest. On this case, it's a grand theft, not a violent offense, Judge. I'm going to be asking the court to consider a straight ROR. If the court's not inclined for a straight ROR, I'd be asking the court to consider releasing him on pretrial release.
Does he have any priors?
I don't know if he has a juvenile history or not.
All right, we'll put it on recall while they look it up. Ladarius Richardson.
Mr. Richardson is here present at Main, Judge. Come on up, sir.
Mr. Richardson, you're accused of grand theft auto And then you have some traffic violations and a possession of cannabis less than 20 grams. The court finds probable cause on count 1 and 4. Bond in the amount of $1,000 on count 1. ROR on count 4. If you have anything to add, counsel.
Judge, unfortunately, Mr. Richardson is homeless.
Okay.
So financially,
So that's
he is
not gonna-
indigent. He's 21 years old. He can't afford to post any monetary bond. He's asking me to ask the court for a straight ROR.
One moment, Judge. And I'm showing, this is Ladarius Richardson,
This is Ladarius Richardson, who is allegedly...
showing he's on probation till the end of this, one moment, Your Honor. I'm showing he's on probation till the end of this month for Grand Theft Auto.
Okay, well, what's the case number?
Judge, my understanding, speaking to Mr. Richardson, he spoke with his probation officer last week. His probation officer advised him that his probation was terminated last week.
All right. I'm going to give him the benefit of the doubt and not order the probation revocation in light of that, but the court's going to set bond amount of $1,000 on count 1. Akeem Wiltshire?
19. But he bonded. Judge, I've been informed he bonded.
All right, so I guess the out-of-county hold is $5,000, and the court finds probable cause and $1,000 on count 3. Tyrone Thomas?
Mr. Thomas, come on up, sir.
Mr. Thomas, you have capiases on counts 1, 2, and 3 for tampering with a witness, resisting, obstructing without violence, and violation of a restraining order. You'll be held no bond on all 3 counts. And then what's count 4? And count 4 is just a violation of probation, which will also be held. Oh, violation of injunction. No bond as well. The VOP is in front of Judge Usan. Your next court date is 1/16 for the violation of probation and 1/17 for the other offenses. Michael Edward Corker.
I've been advised he bonded, Judge.
Okay. Court does find probable cause on counts 1 through 4. Count 4 has a bond of $1,000. So there's just no charges at all of the other 3? They just do RORs?
Yeah, it's
okay.
How the bond schedule works.
Thank you. Omar Paez?
Paez, I've been informed he bonded as well, Judge.
All right. PC on count 1. Bond is $1,000. Savon Wright. Mr. Wright, you're here accused of possession of cannabis less than 20 grams, fleeing and eluding, reckless driving, and then some traffic offenses. The court finds probable cause on count 1 and 2. Anything to add, state or defense? Bond on count 2 will set in the amount of $2,500. And ROR on count 1.
Thank you, Judge. I'll contact your mom right after court, okay? Good luck.
Piero Dempsey?
Mr. Dempsey is here present, Judge, at Maine.
You're here today accused of battering a law enforcement officer and resisting, obstructing with violence. The court finds probable cause on count 1 and 2. State?
Requesting $1,500 bond on count 1, $500 bond on count 2.
Defense?
One moment, Judge. Judge, having spoken to Mr. Dempsey at this time, nothing to add. That's reasonable.
All right, the court will set bond amount of $1,500 on count 1, $500 on count 2. Steve Hippolyte?
Medical reset.
Okay.
Your Honor, I'm not sure if this was done before. I would ask if the court would be inclined to make a probable cause determination. I have no objection in being brought back for a bond, but as you can see, this is matters, it's going on a week now being reset.
I don't know that I can without his presence.
He doesn't, under the
You
rules of
can.
procedure, he doesn't need to be present.
Okay, then
Yeah, I don't have a problem with that, Judge. I've reviewed the probable cause several times in this case.
The court has also reviewed the probable cause, and the court does find probable cause on counts 1 and 2, and will reserve on the amount of bond, what's appropriate, when he can join us. Probable cause determination for Woodland EMA?
He's in North Broward, Judge. I'm not sure if he's a medical reset or not.
EMA, is there anybody there? Well, there's nobody there, so I guess
Yeah,
it'll
I
be
can see
reset.
the deputy is there. I don't
All right, we'll reset that, hopefully. Nathan Burke,
North Broward.
nobody there. Medical reset,
There's
okay.
I see a deputy there.
Paperwork said medical reset. Blake Oppenheimer.
Copy, Your Honor.
Your Honor,
Mr. Oppenheimer, you here today for burglary of a conveyance and battery? You may. Thank you.
Mr. Oppenheimer is represented by Bill Lorenzo. He was here earlier and he and I spoke, and we're in the same opinion. As you can see, this is a technical change of charge.
Correct.
As you can see from the original finding, a finding was made for burglary with a battery, and he was ordered to be held no bond. I imagine, and I provided the court with a copy of the information, I imagine because we filed it as burglary of a conveyance with a battery, the computer treated it as a change of charge, technically, and it went back to no bond hold for magistrates, but...
All right, still going to be a no bond hold based on...
I'd ask the court to adopt the previous findings.
And the court will adopt the previous findings on this case, and I don't have to rule on counts 2 or 3, right, because those are not before me.
Exactly.
Okay. All right, so order. All right, good luck, young man. Kaylin Maddox.
Paul Ryan, Your Honor.
Paul Ryan. Mr. Maddox, good morning. You're here today, charged with aggravated fleeing and eluding. This is a change of charge from aggravated fleeing and eluding with property damage. It's now aggravated fleeing and eluding high-speed reckless. You may.
Your Honor, I provided the court with the original findings from Judge Murphy at his original first appearance. Judge Murphy set the bond at $1,000. In light of the fact that I believe, and Brian, can you confirm he has no bond probation holds?
That is correct. He has no bond violation of probation
I'm
holds.
just going to be asking the court to set the $1,000 bond back.
All right, the court's going to adopt the findings of Judge Murphy and set bond in the amount of $1,000 as previously ordered. Good luck to you. Claxton Kendrick.
Your Honor, if I may...
He is here present, Judge at Maine.
Mr. Claxton, you're here today accused of possession of cocaine and violation of probation.
It's on the second page.
Okay.
Maybe you're not. I know I was.
Yeah.
Which, the first page ends missing the most
Valtox
important
positive.
word. Yeah.
Oh, the found to be on probation for accessory after that, yeah.
Oh, no, it should mention,
And then I swear from, okay.
cocaine.
Yeah, oh,
the
that's
second
funny.
page.
Yeah, cocaine. All right, the court does find probable cause on count 1 for possession of cocaine, and court does find that you were placed on probation, and this probable cause on this charge constitutes a presumptive violation of that probation pursuant to 948.06. Is going to hold you no bond on the violation of probation.
I was like, of course, that's what it would finish on.
Thank you for catching that. Sean Christopher Douglas.
Mr. Douglas is here present at Maine, Judge. Come on up, sir.
Good morning, Mr. Douglas. You're here today accused of aggravated battery on a person 65 years of age or older. Is that on a warrant?
It's a not in custody, Judge.
Okay.
And Your Honor, just to advise the court.
And then it's 74 years of age. Okay.
Well, no, it's actually filed, and I'm looking at the information.
Okay.
It's filed as a battery on a person 65 years of age or older, not an aggravated
Oh, thank you. All right, so that'll make that a battery. And the court does find, well, I don't need to find probable cause because you've already filed.
I mean, the court has to find probable cause, but you could base it on the not in custody capias that was issued.
All right, so the court does find probable cause. And are you requesting no bond?
Your Honor, I'd be requesting a $7,500 bond based on the age of the victim and the allegations. And, Your Honor, I would also be asking.
Does he have any priors? Because I find these allegations alarming.
Okay, I'm not, and that just so the court's aware, and I should have mentioned, I don't see any criminal history.
Okay.
And I reviewed that before I made the recommendation. Regardless of whatever bond the court deems appropriate, I'd also be asking for an order of no contact with GS.
All right, what say you, defense?
Geraldine.
Judge, my understanding, if I heard Mr. Lender correctly, I believe this case is filed. Is it filed as a battery on a person? So a third-degree felony?
On the person 65 years of age or older, yes.
Yes, okay.
Regular battery.
Having said that, Judge, he's 19 years old. He's been
Does he live in
living
that
in
home?
Florida. He does, Judge, and I understand if the court orders a no contact, he does have a separate place to live with his aunt that he could reside with. Judge, he's unemployed right now. He's looking for work. He was previously working about a month ago at an audio warehouse, making about $10 an hour. And right now he's actively looking for employment. Judge, I'm asking at this time, considering this is a third-degree felony, I'm asking the court to impose a $2,500 bond on Mr. Douglas' behalf.
Court will impose a $2,500 bond, but the court's going to add a condition of pretrial release with the monitor and no contact with the victim, and he must stay at least 500 yards away from her or her home or any place he thinks he might run into her.
The court did say 500 yards, correct?
500 yards. If she goes to church, he doesn't go to that church. If she goes to the Publix on the corner, he doesn't go to the Publix on the corner. Stay away from her until such time as this case is resolved. Thank you. Eric Martin Grant.
Mr. Grant is here, present, Judge Amanda.
State, I have a question.
Who's this, Your Honor?
On Mr. Grant?
Oh, Your Honor, it's a perfection. I have nothing to add, so he is entitled to an ROR.
Oh, okay, thank you, because I was going to say. So ordered.
Here, let me just try to print out the first 5 pages.
All right, recall back on Mr. Carter. Did we find with Mr. Carter have any priors?
Did you find anything?
No PC on all counts on the last one, yeah.
It doesn't appear there's any history, Judge.
Okay.
So, Judge, based that this is a nonviolent offense and there's presumption to be released on non-monetary conditions, Judge, I'm going to be asking for a straight ROR on Mr. Carter's behalf.
The court will consider pretrial release. Would he like to do that?
Yes, he would, Judge.
All right, so order.
Here's a message report there today. In order to check it. If not, there's going to be a warrant issued for your arrest, okay?
Do you want to recall Mr. Baker or wait to see if Mr. Polay is going to come? Or?
We can recall it, Judge. I did speak with Mr. Polay earlier. He did come by and pick up some paperwork. He picked up the copy of the affidavit. He indicated that Mr. Baker is aware that he is being held no bond on a violation of probation and just asked for whatever reasonable bond the court would consider to impose. And I believe he has court tomorrow.
And Your Honor, I also spoke to Mr. Polay, and he represented to me, he understood it. One way or the other, he's going to have to go in front of Judge Siegel.
Right, and that's tomorrow.
So your recommendation on counts 1, 2, just the no bond at this time?
On count 1, upon a review of the arrest warrant affidavit, I am going to be seeking a no bond upon finding proof evident or presumption great for first appearance purposes. On 2 and 3, I'm going to be requesting $50,000 each, and on 4, considering that is the same charge he's on probation for, I'm going to be requesting a $15,000 bond on that.
So the court has reviewed the probable cause that affidavit. The court does find probable cause counts 1, 2, 3, and 4. On count 1, the court finds that the proof of guilt to be evident or the presumption great, and therefore it's going to hold you without bond until further order of the court. The court's going to set bond on count 2 in the amount of $50,000, count 3 in the amount of $50,000, count 4 in the amount of $15,000.
And, Your Honor, in an abundance of caution, I would just be asking for an order of no contact with Millicent Roberts.
And no contact, either direct or indirect, with the victim in this case, Millicent Roberts.
And also, Your Honor, James Baker.
And James Baker.
Thank you.
Thank you very much. We're off the record.
Judge, we had Nathan Burke.
Oh, we missed one? Oh, sorry, here it is. Nope, I don't have that paperwork. What did I miss?
Might have got passed back over with the recess.
Okay. North Broward? Mr. Burke?
North Broward, Your Honor.
Hi, Mr. Burke. Can you find? Yeah, thank you. Hi, Mr. Burke. You're here today accused of petty theft and corruption by threat. The court does find probable cause on count 1 and 2.
Ma'am.
Yes, sir.
Ma'am.
Just let me just advise you that everything you say is being recorded and will be used against you. So I advise you to remain silent, okay? Other than to talk.
I want to speak. We're not arguing the facts. We're not arguing the facts of the case. I would like you to throw the charge out, because these are just military tribunal courts. And it's all about commerce. If you could tap into my security and get them discharge the debt from my security, I really appreciate it. Because I would like to go home.
Okay, I'm not real sure about which security you're referencing to.
My birth certificate.
Okay.
We're not arguing the facts of the case. I just want to go home. Can you throw it out?
No. I can only determine if there's probable cause or not, and I have determined that there is probable cause. At this time, though, I'm going to ask for a medical review again. Or did he already go?
I don't know, Judge. I know that there are issues to be dealt with here involving Mr. Burke.
All right.
I'd ask the court.
Not sure what to do about.
Well, we're going to send somebody up to see him. He's not going to be able to make a monetary bond.
Right. And then
so
I'm just concerned that he's not going to have the capacity
2.
to report back and then end up being held even longer.
It's possible.
You're out of your jurisdiction. I'm under alias.
Okay.
And, Your Honor, just based on the nature of the allegations, I'm going to be requesting a $2,500 bond. Obviously, it seems this is going to have to be dealt with in his assigned division, where they're probably more equipped to.
You're out of your jurisdiction. You're out of your jurisdiction. You know it. You're out of your jurisdiction. I'm under alias.
All right. Well, what is your real name, sir?
It isn't Nathan Burke. That's just a corporation.
Okay.
I'm under here under duress, so we're not.
Judge, I'm fine with a $2,500 bond.
Well, court's going to set bond amount of $500 on count 1 and 2, and then open to review at any time. Thank you.
Listen.
All right. Thank you.
Thank you, Judge.
All right. Off.